We start with a heavy dose of reality from the bench. The judge immediately spots a tactic often used by defendants looking for sympathy, bringing a young child to a sentencing hearing. While some might see a family man, this judge sees a calculated attempt at manipulation. By ordering the child out of the room before the case even begins, the court sets a firm boundary. It is a powerful opening that signals this judge is not interested in theater. He is interested in the law and the direct consequences of the defendant's actions. He makes it clear that the presence of an infant won't soften the blow of justice. This initial confrontation sets a no-nonsense tone that remains throughout the entire hearing. It is the first sign that this defendant has severely underestimated the person sitting behind the bench today.
Yes, Trevante Bryant. 2 will be 716 3361.
Michael Carmen, B7384, on behalf of the defendant, Your Honor.
Your name?
That area is
What, are you bringing your kid to court because you know you're going to go to jail?
No, Your Honor.
Don't play games with me.
I'm not playing.
Don't play games with me. I don't want people playing games with me.
I don't play any type of.
Listen, you better call somebody and have them come and get that child. You understand?
Yes, Your Honor.
Now, and then we're going to call the case. What I'm going to do, I'm not quite sure, but I've seen this little trick before. I mean, I didn't just get here 2 months ago, okay? We'll call somebody to get the child. I'll call the case when we're ready. And I'm telling you, if you leave, you're going to have a big problem with me. You understand what I'm telling you?
Yes, Your Honor.
The defense tries to pivot the narrative towards stability, highlighting the defendant's employment and his role as a provider for 2 young children. His attorney argues that jail time would dismantle this fragile family unit, painting a picture of a man on the right path. However, the tension builds as the prosecutor reveals the charges: breaking and entering a vehicle to steal property. The contrast between the image of a responsible father and the reality of a serial car thief creates a friction that the judge is clearly feeling. The lawyer keeps pushing the narrative of a hard-working man, but the evidence of criminal behavior is hard to ignore. It is a classic struggle between the defense's rehabilitated image and the defendant's actual history. You can almost feel the skepticism growing as the lawyer lists the weekly earnings and family ties. This part highlights the massive gap between the defendant's lifestyle and the legal standards he keeps failing to meet.
Tyarius Trevante Bryant. 2-4, please, 716-3361. Are you guys hearing this case, victims? No?
They're not.
All right, Mr. Carmen, your name?
Michael Carmen, B7384, on behalf of the defendant.
Mr. Bryant, come on to the podium, state your name. According to you, you're, I want to ask again. Just double check, Mr. Timberly Dennis, Durley, Margarita Bruno Hayward, Joseph Matthews. Are any of those individuals, bring Mr. Mohammed. Yes. Any of those individuals in here today? All right, it does not appear as though they're on Zoom. They did not step forward on the case when called. Mr. Carmen, why don't you and your client approach the podium, please, and then tell me whether or not there's any material additions, corrections, or deletions.
Your Honor, as far as his employment status, he, since January of 2024, has been working at Cosmic Comics, both in Livonia and Fraser. Both locations earned $340 a week. They'll lose that job if he has to go to jail. He has been living in Romulus with his girlfriend. They've been together since 2019. They have 2 children together, ages 1 and 7 months. He just made arrangements for her to pick up the 7-month-old. Your Honor, he's not been incarcerated in several years. He does have a pending matter in Wayne County that's set for sentencing next Monday.
Mr. Mohammed, your name?
Good morning, Your Honor. Mohammed on behalf of the people.
You wrote down full restitution on this. I just want you to be aware, this is the B&E vehicle to steal property, 200 or more. I just want you to be aware that none of the victims are here. Or less than 200, I'm sorry. He pled the count. Count 2 was dismissed. He pled. Lisa, just confirm that my understanding is correct. It looks like he pled guilty to count 1, which is the 1 year, and count 2 was dismissed. Is that true?
That's correct.
So I just want you to be aware of that.
And Judge, I apologize. Which case is this?
This is Triarius Travantity Warning. It's a B&E vehicle to steal property 200 or more, but less than 1,000. It's a 1 year. So I just want you to be aware. I called the names. You're not here. You just put down PSI full restitution, and none of them show. So I'm not going to order any restitution out of this.
And Judge, may I ask, does the court send notices to them or?
Yeah, we did send notes.
Okay.
The probation department did when I ordered the pre-sentence report.
So,
Okay.
I understand, Judge. Thank you.
All right. Anything else, Mr. Carmen?
Yeah, since my client shares, the care and custody of 2 young children, his girlfriend that he lives with. If he's got to go to jail, it's going to be very hard on our young.
The judge delivers a searing reality check that cuts through the excuses. He acknowledges a hardship on the family, but flips the script to focus on the victims whose privacy was violated. His commentary on responsible fathers putting their children above antisocial behavior is a verbal hammer. He then begins to dismantle the defendant's character by listing a long history of noncompliance, domestic issues, and retail fraud across multiple jurisdictions. The defense's plea for mercy is quickly drowning under the weight of a very long rap sheet. He points out that true fathers don't break into cars and steal items, effectively silencing the defense's primary argument. This is where the judge stops being a neutral observer and starts holding a mirror up to the defendant's lifestyle. Every word feels like a strike against the defendant's credibility. The tension in the room is palpable as the judge lists felony after felony, proving this isn't just a one-time mistake, but a persistent pattern.
Before we go out, steal? I mean, seriously.
I understand.
I don't know if you do or not. I find it a little hard to believe. I mean, you could sit and give me lip service, but you had a RNC motor vehicle in 2021. You had a domestic where you didn't comply with probation in 22. Conviction was entered on that. You had a retail fraud in 23. We're just convicted of felony retail theft in Illinois. We have another case you're bound over to the 33rd, bound over from here, stealing or retaining without consent a financial transaction device. Is that the case he's going to be sentenced on?
Yes, Your Honor, and there's a sentencing agreement in that case of 2 years probation.
I mean, that's great.
Letting just inform the court.
No, I get it. I'm just telling you, he's got bench warrants out of the 34th for assault and battery. Bench warrant out of the 52nd for retail fraud 3. The bench warrant for retail fraud 3 out of Southgate. Retail fraud bench warrant out of the 16th. Go up on any of those?
Yes, Your Honor.
When?
I've been taking care of the warrants since I've been out, Your Honor, and
Lisa, can you run his lane again for me, please? This lane
Sure.
is a few days old. Let me just double check.
And my client indicated he's contacted those courts.
You contact.
yes, Your
What
Honor.
do you mean?
I contacted those courts and they told me that I have to turn myself in and schedule those.
Well, you haven't taken care of the warrants then, have you?
No, I have been taking care of some of the warrants, Your Honor.
I'm sorry?
I have been taking care of a
All
number.
right, I'm gonna just check with her and see. Now you're breaking into cars. I mean, I don't know what to tell you. You've been unemployed, and then you were working at Fast Splash Car Wash. You collected money on a bridge card. You need to go back and get a GED or a diploma. You need to work harder. I don't know why you're not working. You need to work. That's your decision though. But to go out and support a family by eating all the time is not the answer.
Your Honor, he is working, and I updated the court on that.
I know you did, but still, this report was just done, right? This report was just, let me just double check this. I ordered the pre-sentence report on March 25th. I'm just telling you that they reported then that he was unemployed for the past 8 months. Why were you unemployed for the 8 months preceding that report?
I wasn't unemployed, Your Honor. I was just helping my baby mother going through the postpartum and dealing with the kids. I was still working,
Well, you told them you were unemployed. Reports being unemployed for the past 8 months.
and I don't know why I put that, and I shouldn't have put that. I've been working since January 2024.
All right. At least you don't see any of those other warrants. I think you just answered my question. You don't see any other warrants cleared out of the locations I just mentioned, right?
I'm just running it right now. Give me 1 second.
Yeah, take your time.
No, I don't see any other warrants.
You don't see what?
I don't see any other warrants.
Well, I'm just saying, see the lead in here, but probation reported open warrants issued the 37th District Court, 16th, the 28th, the 34th, and the 52-3 District Court. Do you see any of those warrants on his lien now?
No, I just ran it and I do not see any warrants.
Good. All right, well, anything else?
Nothing, Your Honor.
He did not spend any time in jail on this, correct?
No.
Where's the child now?
She's going, Your Honor.
I'm sorry?
She's going, Your Honor.
Was the mother of the child here?
No, she wasn't here. Someone else came and picked her up.
You're supposed to mean like you become a professional thief. 200 fines, 400 costs, 75 victims' rights, $50 justice assessment, 7 1/4, and 40 days jail. You'll serve 325 more if you don't pay your fines and costs. I'll let you pay those at the rate of $75 per month. And I will let that start beginning on June the 15th. If you don't have the money at any point, you call the court. I'll be happy to give you an extension. You have 21 days to write it over.
The suspense ramps up as the judge digs into a list of active bench warrants from various district courts. The defendant tries to claim he has been taking care of them, but his vague answers only make things worse. When he claimed he was told he had to turn himself in to schedule a court date, the judge points out the obvious. If you haven't turned yourself in, you haven't taken care of the warrant. This back and forth highlights a pattern of avoidance that clearly exhausts the court's remaining patience. It becomes a game of legal cat and mouse where the defendant keeps trying to find an exit that doesn't exist. He mentions contacting the courts, but the judge sees through the empty words immediately. There is no middle ground here. Either the warrants are cleared or they aren't. This segment proves that you can't just talk your way out of documented legal failures. The judge's frustration is visible as he realizes the defendant is simply giving him lip service.
B716-3361. Mr. Bryant, you need.
Here is Brian.
Listen. I'm not going to put up with you yelling and screaming back there anymore. If I have to call you out here again, I'm going to give you 30 days for contempt on top of the time that I just gave you. 30. You don't get to act like that. I hope you clearly and fully understand me. If you don't, I'm going to have you out because I would hear you again. And then I'm going to lock you up for 30 days. And we're going to do this all day long. You're not going to make a scene here in the courtroom. That sentencing, if anything, was too light. I'm not playing with you.
How was it too late?
Mr.
I have a judge that I gotta go to felony court. This is a district court. I got sentencing on felony court.
We see a classic courtroom trap involving the defendant's employment history. While his lawyer claims he has been working since January, the official pre-sentence report states he was unemployed for the 8 months prior. The defendant tries to blame the report or his own poor communication, citing childcare as a reason for his lack of work. The judge is not buying the flip-flop. This segment exposes a lack of credibility that eventually seals the defendant's fate, showing that honesty is usually the only way to stay afloat. The judge points out that the defendant himself told the probation department he was unemployed. Now, suddenly, a new story emerges because it sounds better for sentencing. This kind of inconsistency is exactly what a judge hates most. By trying to look better, the defendant actually makes himself look like a liar. It's a painful moment to watch as the defendant struggles to explain why his story keeps changing under pressure.
And go tell them. You have 5 or 6 theft offenses, you're breaking into people's cars. You just think you could make a living by being a thief?
But I'm not a thief.
Oh, okay. Have a seat in the back, speak up again, you're getting 30 more days, I promise you, that's not a threat, it's a promise.
Bro, I don't give a fuck.
Good, come here, contempt of court, bring him up.
No, bro.
You're gonna send another.
You're gonna get I got people saying, I don't care. You know, not the moon, kill up. People stop for kill me. Be over. Run over flat. Flat. Run shit over. At all. So I got surgery on Monday night. You got fuck on my shit. I'm assisting. Oh my man. Stop. Fuck with me, bro.
All right. Settle down.
You off, man.
Go down.
No, you're gonna get taken, bro. Taste me, Jimmy. Taste me.
We don't want it. We don't.
Taste me. Stop resisting. Like I got kids that I never raised by myself.
You ain't making it ain't dying.
You keep making it seem like I'm just a thief. I gotta prove that I was see what you're doing.
Knock
I gotta prove
Knock
that
it off.
first.
Knock it off.
Hey, listen to me.
Right.
Look at this. You're making it twice as bad.
Mr. Bryant, go back in the back. I'm gonna let bygones be bygones, except for the initial jail term. One more word, and I'm telling you, you're doing 30 more days.
How many days?
Enough. Just control yourself.
Okay.
Stop speaking.
The gavel drops on a 40-day jail sentence, and the situation immediately turns volatile. As the defendant is led away, he begins yelling from a holding area, prompting the judge to call him back for a stern warning. This is a turning point where a fair sentence starts to transform into a much longer stay. The judge threatens 30 days of contempt for every outburst, making it clear that the courtroom is not a place for temper tantrums. The defendant's inability to accept the ruling is creating a massive legal hole. He thinks he can scream his way to a better outcome, but he's actually just adding more time to his clock. The judge's patience has officially hit zero, and he makes it clear that he will do this all day long, if necessary. This isn't just about the sentence anymore. It's about the respect of the court. The defendant is standing on the edge of a much larger disaster, and he doesn't even realize it yet.
Oh, okay. Enough. Just control yourself. Stop.
In a bizarre move, the defendant tries to lecture the judge on judicial hierarchy. He believes that because a higher circuit court gave him probation for a felony, this lower district court shouldn't give him jail for a misdemeanor. It is a bold, albeit foolish, strategy. The judge reminds him that his history of theft is the reason he is sitting there. When the defendant finally snaps and says he doesn't give a damn, the judge immediately calls his bluff and orders him back to the podium for a formal contempt of court charge. He tries to justify his behavior by claiming he isn't a thief, despite the literal evidence in front of the court. The judge's sarcastic response of, "Oh, okay," is the ultimate shutdown for this delusional argument. You can see the defendant's ego getting in the way of his freedom. Instead of staying quiet and serving his time, he decides to double down on the disrespect. It's a masterclass in how to ruin your own life in under 60 seconds.